Well, good morning, everybody, and I think we're nearing the end of our allotted time, so I'm going to go through things, my piece of this fairly quickly. But first, I want to thank my colleague, Gary Feldman, for clarifying the nature of my relationship to the marijuana issue. So I'm the vice chair of the Marijuana Committee, and we're looking at the ballot initiative that was passed by voters. And so let me go through. I'm going to there are hundreds, even thousands of bills filed every session. And so I just want to focus on four that I think have some momentum and that are substantial, significant. One is actually a bill I introduced called the Pregnant Workers Fairness Act. And the serendipity, the timing is noteworthy. It passed on the floor of the House yesterday unanimously. So every Democrat, every Republican, the Senate is going to take it up. And Governor Baker was interviewed, I think, on NPR or another outlet, and he said if it passes in the form that the House passed it, he's going to sign it. So for those of you who are employment practitioners, human resources professionals, this is coming. It's going to be law. And it amends the state anti-discrimination statute, Chapter 151B, to make it unlawful to refuse to provide a reasonable accommodation for an individual due to a pregnancy or a condition related to pregnancy. It essentially tracks the same concepts as disability law. So employers must provide a reasonable accommodation. And the law actually sets forth a list of what is a reasonable accommodation. It's not an exhaustive list, so it's included but not limited to. But there are things like more frequent, longer breaks, light duty, job restructuring, temporary transfer to a less strenuous position, a private non-bathroom space for expressing breast milk, assistance with manual labor, and modified work schedules. So that's not an exhaustive list. Again, the law is clear that there could be other things. Employer is not required to provide these accommodations if it would impose an undue burden. Again, just like other disability law. And the factors there are the cost and the nature of the accommodation, the employer's overall financial resources, the size of the business, and the number, type, and location of facilities. And this applies to employers of 6 or more employees, so even quite small employers. The next item I want to talk about is paid family and medical leave. And that obviously would be a huge and substantial change in public policy affecting the workplace. And a colleague of mine, it's his #1 issue. He's pushing it hard. It has some traction. Right now, across New England, about 12% of employees already have access to some form of paid family or medical leave. 4 states have laws that do this. And in each case, the states that provide it do so by adding a benefit to a pre-existing temporary disability insurance program. We don't have such a program in Massachusetts, but this law would create it. And the proposal would create a right very similar to the Family and Medical Leave Act to recover from a serious illness or injury, to care for a seriously ill or family member, or to care for a new child. And it would create 12 weeks of paid leave. In the case of recovering from your own serious illness or injury, 26 weeks. The leave can be taken on an intermittent or reduced leave schedule with the authorization of the employer. The premiums to cover the cost of the leave would be shared equally between the employer and the employee. And there's a 7-day waiting period that would be in the law before the benefit kicks in. It's a graduated temporary disability benefit. I think the maximum is $650 a week and to be adjusted with inflation thereafter. And the bill would actually create the Department of Family and Medical Leave within the Executive Office of Labor and Workforce Development. So it'd be a whole new agency with a director appointed by the governor. Employers can establish a program by making payments to a Family and Employment Security Trust Fund administered by the state, or by a private plan or agreement including an insurance policy, collective bargaining agreement, or company policy, which must be approved by the department. So that is a major piece. It's brewing, and it's impossible to predict what's going to happen, but whether it passes this session or next, I think it's a concept that has some momentum here. Just two more to go through. Non-competition. I don't know how many of you followed this last time. A non-competition bill for employees made it all the way to a conference committee. So the way the legislative process works, of course, the House passes a version, the Senate passes a version, and then 3 people from each body are appointed to a conference committee to negotiate differences. And those conference committee negotiations can be contentious and difficult. I thought, well, the Democrats control the House and the Senate, how hard could it be? But it turns out each body really fights hard for its version. Last time the negotiations broke down over garden leave provisions and what some call a reformation provision, meaning if non-compete is too broad, can a judge reform it or is it discarded entirely? And those two issues apparently in conference committee caused the legislation not to move forward. The bill that's in the House right now has a few things that I'll go through quickly. It must be in writing and inform the employee of the right to consult counsel. It must be provided by the earlier of a 2-week period prior to commencing employment or a formal written offer. That can be waived in writing, that requirement. And if you present the non-competition contract to the employee after employment is commenced, continuing employment alone is not adequate consideration. An interesting twist, it must be reviewed every 3 years. So you can't just put it on the shelf and assume that it will remain valid. Every 3 years, the employer and employee would have to review it. The scope, of course, that's always the issue in the big issue in non-competes, is a 12-month limit on the duration of non-competes, unless there is a breach of fiduciary duty by the employee or theft, in which case the duration can be up to 2 years. Geographic scope also has to be reasonable, and there's a presumption in the law that if it covers the area where the employee operated, it's presumptively geographically reasonable. And then there's some carve-outs. I won't go through them all, but one example is if you're terminated without cause, the non-compete is invalid. So the concept there, of course, is if the employee didn't violate any company policies, terminated without cause, you can't tie them up in a non-compete. And then the final item I want to discuss is the minimum wage. And you may have heard this in the press. There's a so-called fight for 15 going on right now. We have a minimum wage right now of $11 an hour, and there is a coalition of labor groups and community groups, religious groups, all fighting for a piece of legislation that's pending now to gradually move up the minimum wage to $15 an hour by the year 2021. Interestingly, it would also take the tipped minimum wage. Obviously, you go to a restaurant, waiters, servers make less than the minimum wage and make it up the difference in tips. This would gradually raise the tipped minimum wage up to the regular minimum wage. It estimates, estimate is it would impact about 29% of the state's workforce, roughly 950,000 workers, 57% of whom work full-time. And of course, what labor market economists would tell you is if the minimum wage goes up for employees at the lower end of your wage scale, it's going to put pressure on wages across the board. So I think for those of you, again, in human resources, in management, or employment lawyers, it's something to be aware of, that this is a public policy debate happening in our state right now. And I primarily practice in the area of corporate law, mergers and acquisitions, licensing, but I also do some employment law incidental to that. And I'm happy to be a resource to any client of the firm as to what's going on Beacon Hill. If there's either in the employment law area or otherwise, if you just want to know, hey, there's a bill pending, what do you think? Does it have momentum? That's certainly the kind of question I can answer. So thanks a lot.
Does anybody have any questions about any of the topics that we talked about?
Okay, so the question is in conducting the survey that we talked about to provide a defense in terms of auditing, surveying your pay practices, or perhaps even compliance under the law once the law becomes effective. Since how do you identify an employee who doesn't identify with a particular gender for analysis of comparing male versus female? So I don't have an answer for you at this point, Patty. I'm hoping that the Attorney General, either in their regulations or their guidance, will shed some insight onto that. That's a very good question, and hadn't even quite considered that at this point. Anything else? We'll be here if anyone wants to chat, catch up with any one of us, but we don't want to hold the rest of you up who've got your day jobs to get to. So thank you all for coming and attending.